you are being completely disrespectful to these court proceedings. I need you to understand that. I will let you speak with Mr. Fahrenholtz after direct examination and before cross-examination.
Okay, Your Honor.
Okay?
Yes.
All right. Let's try one more time.
Okay, Judge. Sergeant, I've just handed you what is labeled as People's Exhibit 1. Do you recognize this?
Yes.
Is this a fair and accurate representation of the patrol vehicle video on the night of January the 18th, 2025?
Yes.
How do you know that?
So we observed it at our first meeting, and then I signed it today.
Thank you. Your Honor, the people would move to admit and publish the fleet camera video.
Any objection, Mr. Fahrenholtz?
No objection.
Exhibit 1 will be admitted.
Did you see what happened right there?
Yes.
Could you describe what happened?
The vehicle weaved over the solid white line.
So that was right after you started following the vehicle?
It was actually one more incident, the reason why I initially activated my dash cam.
Okay. We're going to play this a little bit more, and we're just going to kind of silently count to yourself how many times you see that particular type of behavior.
Don't do that shit.
Sergeant, we are 3 minutes and 14 seconds into this video. How many times roughly did you see the defendant weave?
5 to 6 times.
Is that the reason that you initiated the traffic stop?
Yes.
So what would you call that? Erratic driving, weaving?
Weaving with the jerkiness of the motion, extended use of a turn signal without changing lanes, her inability to maintain a speed. If we go back, we could actually, I don't know if your option has it, but you could see my speed and it was fluctuating and see how you could hear I'd have to.
All right, buckle up, because this is not your average courtroom clip. This is one of those rare cases where the drama doesn't just build, it explodes. Today, we're diving into a hearing that starts off like any routine DUI case, but quickly spirals into pure chaos. And at the center of it all, a defendant whose behavior is so disruptive, so defiant, that even her own lawyer, who's working for free, reaches his breaking point. Now here's what makes this case different. It's not just about the charges, it's about control.
I mean, interrupt. I thought he was done. We're not contesting reasonable suspicion for the contact. We're not contesting the stop.
And
I understand the purpose of.
Well.
Yeah.
Just to make sure you're
But
protesting probable cause.
I think.
Yeah, it goes to probable cause.
Oh, well, if you protest probable cause, then these are indicia of intoxication.
Yeah, I just wanted to clarify, we're not contesting the stop.
Understood. And I understand why you're asking these
I do
questions.
too.
Okay, so I'm just going to build the record.
Go ahead.
This would be considered probable cause in your experience to pull somebody over for a traffic stop?
Yes.
Thank you. And did you pull the defendant over?
I did.
What happened when you, well, let me ask this. In your experience, do people generally, when they see police lights behind them, pull over relatively quickly, or does it take them a long time?
For the majority of the people on traffic stops, it's a relatively quick pull over to the shoulder of the road.
So I'm going to play this just initiating the stop here to see how long this takes. That is 3 minutes and 56 seconds. So that's roughly 40 seconds-ish of a stop. Is that something that you typically see in a traffic stop?
I felt at that time it was a little long.
So what happened when you made contact with the defendant?
When I approached the vehicle, made contact, I requested her driver's license, insurance, and registration. She advised me that she does not have a driver's license. Upon further questioning, she told me that it was a revoked license. I asked her how much she had to drink because I could smell a strong odor of alcohol coming from the vehicle. and she told me she had nothing to drink, advised me that she was coming from a doctor's appointment in Denver, and then advised me that she did not have insurance on the vehicle.
Your Honor, may I approach?
You may.
I'm handing you out with this label as People's Exhibit 2. Do you recognize that?
Yes.
How do you know what it is?
We reviewed it on our first meeting, and it has my signature with today's date.
Is it fair to say that is an accurate representation of your body-worn camera on January the 18th, 2025?
Yes.
Your Honor, people move to admit and publish.
No objection.
Exhibit 2 will be admitted, we may publish.
Okay, did you catch that? The officer just referred to the defendant as an adult toddler in open court. That's not just unprofessional, it's explosive. Now, while that kind of language can absolutely raise eyebrows, what's more important is what it reveals about the situation. Officers are trained to remain composed, especially on the stand. So when someone slips like that, it usually means they've already had a very difficult interaction with the defendant. And look at the judge's reaction. She immediately redirects the situation, trying to maintain control and keep things professional.
Can you pause it for just a second? Ms. Engelova, repeatedly you are interrupting these proceedings. There's evidence that's playing right now.
Okay.
So I don't want you to talk. I don't want you to slam your book down. I don't want you to
I'm sorry.
interrupt this.
I'm sorry.
Stop it. You need to just control yourself. I need to listen to the evidence. Ms. Fry, you may continue forward.
Here's a copy of the motions if you ever read something. I gave it to you before you didn't even look at it.
Giving it to me.
Give her a lot of goddamn time on this.
I'm not trying to shit on how to fucking
Withdraw.
Sergeant, at that point in the stop, were you still just...
And my mother.
Ms. Engelova, stop talking. Now,
Judge, I might have to withdraw. I'm doing this pro bono.
I see,
and I don't
I see
need-
what's being done.
I put a lot of time into this
I know.
case.
And I see what's being done in open
We need
court.
to have a moment. We haven't even had.
Judge,
Oh,
I would
stop.
ask the
Yeah,
defendant
you
be
were
held in
late.
contempt at this
Could have been
point.
early.
Jesus Christ.
Ms.
I'm dealing with
Engelova,
both
Ms. Engelova, here's the reason why you didn't have a moment before the hearing. It's because you were late. You were 15 minutes late. Now the hearing is proceeding. Stop it. Do not.
I'm a caregiver for an Alzheimer's
You
patient.
also have a hearing today. That
Yes.
you are, I expect you to
I'm
be
sorry
on time.
that I have to deal with
So
medical
that's why
emergencies.
you didn't have a conversation with Mr. Fairholtz, who is trying to represent you, who did file a motion, but all you have done the entire hearing is to stare at him, tell him that he's not doing whatever you want him to do, interfere with these proceedings, and generally be disruptive in court.
I'm sorry.
I know you keep saying that, and I think that you do believe it, but you ratchet right back up. So right now I'm going to tell you that we're going to finish with these proceedings. We're going to finish with this direct examination. We're going to then take a break and you can talk with Mr. Fairholtz.
Okay.
But you are in a precarious situation if you continue to do the things that you're doing. He has indicated that he may have to withdraw. If he withdraws, I don't know what you are going to do after that, but it won't be a withdrawal today. We're going to finish testimony.
This right here is where the tone of the entire hearing starts to shift. Up until now, the judge has been relatively patient, giving reminders, offering guidance, but now she's laying it out clearly. The interruptions, the walking around, the lack of attention, it's all being documented and addressed. And this matters more than people realize. Courtrooms run on structure and respect. When someone repeatedly disrupts that structure, it doesn't just slow things down, it undermines the entire process. And notice how the judge isn't jumping straight to punishment. She's giving warnings. She's explaining expectations. She's even offering a break later.
At this point in the traffic stop, were you anticipating any additional investigation, or were you still just investigating the weaving?
At this point, I was building reasonable suspicion to probable cause for whether or not the defendant was driving intoxicated.
And what did the defendant tell you the status of her license was?
Revoked.
So it's clear that she understood her license was revoked.
Yes.
Stop it. Quiet.
And for the record, Tyler.
Quiet. Now.
Right here, Sergeant Churches, my apologies. You're walking back to the car, and where is the defendant?
Standing outside in front of her car.
Did you ask the
This is
defendant to step out of the car?
No, I specifically told her to remain inside her vehicle.
During this interaction, did she indicate at all that she was cold and wanted to get back in the car?
No, I don't believe so. I believe she wanted, she told me she got out because she needed fresh air.
And at what point during this stop did you decide to arrest the defendant?
At this point of the interaction, due to being on the interstate, extremely frigid temperatures, I elected to place her into custody for the driving under revocation.
Lose all my lawful plans. I don't want anything else to happen. It's as smooth as possible. You're not listening to advance and the first. However, to you're going to be placed in custody. And you're not going to sit on it right now. That is your mouth. I don't want to. I'm not going to go for some time.
Judge, I
know.
I can't do my job.
Now we're getting into the actual substance of the case, and this is where things become very important legally. The officer testifies that the vehicle weaved 5 to 6 times within just a few minutes. That's not a minor mistake, that's a pattern. And in DUI cases, patterns like this are exactly what establish reasonable suspicion and eventually probable cause. Think about it. Inconsistent speed, drifting across lines, delayed response to police lights, each of these alone might raise concern. But together, they paint a very clear picture. And that's why the defense isn't even contesting the initial stop. They know the evidence here is strong.
I can't do my job. I'm going to withdraw. I have to. I've worked hard on this case, and this is just not, I'm doing it pro bono, trying to help out. And
Stop it. Miss Angelova, you are being ridiculous. Ridiculous.
Really?
Yes, you are. You're being ridiculous. You're being disrespectful to the court. You're being disrespectful to your attorney. He's right. He has worked hard on.
This is ridiculous.
Really?
You know what is ridiculous? Having my mom prosecuted by Rachel Fresquez when she was a DA.
Judges,
Do you have any
doesn't even make
motion
sense.
For, is there any competency issues? Any thoughts?
I believe that, that should be a consideration at this point.
Okay. All right, here's what I'm going to do. I am going to order a competency evaluation. I do believe out of custody.
Pay me what money?
competency-
Whatever, back in the day.
Miss Angelova,
2017.
Ms. Angelova, I'm gonna caution you one more time. If you continue with these outbursts, I in direct contempt of court. Do you know what that means? I have directed you several times to stop talking, to be respectful to the court. You have not. If you continue to maintain this level of disrespect, I am going to
I'm gonna look at you.
find you in contempt, which means you will
Because we
be
were
arrested.
dancing this dance
You will
7
be
years ago.
arrested. Are you gonna listen or are you not gonna listen?
I am gonna listen.
What did I just say?
I'm in contempt for telling the truth. Oh, I'm sorry. Rachel Fresquez
Okay.
used to be a DA
Yeah,
who persecuted my mother. I'm
gonna
sorry.
request a competency evaluation.
No, that is not happening.
Yep, that is happening.
No, that is
It's
not
an
happening.
Out of custody competency evaluation. These proceedings.
That is not happening. I am not gonna
Set
comply.
all Proceedings in competency court. I will evaluate, I will advise on the probation complaint at the competency court hearing. There's a current amended complaint. So these proceedings are terminated. And we will, what's the next competency court date? All right, I'm gonna set both these
It's
proceedings.
gonna have to happen after the
Stop
New
talking.
Year.
I'm gonna set,
Really?
if you fail to comply with the competency proceedings.
You're gonna threaten me more than already by this society.
And here it is, the moment where the judge's patience starts to visibly wear thin. Notice the shift in tone. It's no longer just guidance, it's direct commands. Stop talking. Control yourself. These are not suggestions. These are orders. What's happening here is critical. The judge is trying to prevent escalation. Because once things cross into contempt territory, the consequences become immediate and serious. And yet the interruptions continue. The book slamming, the talking over proceedings, it's constant. Now imagine being in that courtroom. Every second of disruption pulls focus away from the case itself. It frustrates the attorneys.
You're gonna threaten me?
Here's the deal.
Sorry for being emotional.
Having-
Sorry for being emotional.
Stop it.
I am not putting
Stop
fingers.
it. I need you to stop it. And you're making it worse. And you're making it worse for yourself.
Because I'm being honest and brutal.
Here's what I need to determine. Here's what a competency evaluation is, okay?
Here is what needs to happen.
You need to listen. A competency evaluation is where you will be advised or you will be evaluated.
As a former nurse who used to work in the rehab center in this valley,
Stop talking. You're going to be evaluated. If you say one more word, I'm going to put you in jail. Do you understand that? Do you understand that?
you really want to put me in jail.
I will if you can't control yourself.
I am trying to control myself, and we're trying to.
No, you are not.
We're not obviously having a conversation.
No, we are not.
No, because I'm emotional and I'm incompetent.
So we're gonna set this in Division 1. I'm ordering a competency evaluation. We'll set in Division 1 on 5th at 1 p.m. That is in Judge Seamus's court, both
For the record,
set
Judge.
on,
Judge.
dates. I'm gonna have you in a minute. I'm gonna have you remove Ms. Angelova.
I will remove myself. I will.
You're gonna appear on December 5th at 1 p.m. in Division 1, that is in competency court, I've tried to explain to you what a competency evaluation is, but you won't listen. So.
I don't need you to explain what a competency evaluation means.
Ms. Anguilova, please.
I will. For the record, can I just make one
No,
statement?
You are to be removed.
One statement for the
No.
record.
No, you're gonna be removed.
Did you get up, Mel?
You need to get up and you need to come back on December 5th.
I will.
We are
I
done
will.
here.
Judge,
We are
Just
done.
for the record,
December 5th, so I don't know if the court wants to grant my motion to withdraw.
You can file it and you can, if you would like to file one, you can file a written motion to withdraw.
I know
At
I'm
that-
not available December 5th. I finally got some time off and I'm not
Okay.
gonna.
before I get removed,
You
And I-
can't appear on that date and time at all. Are you gonna, well, let me ask this. Are you gonna file the motion to withdraw?
Most likely.
for the record, I know there's cameras here.
Can you read?
please.
Please.
Yes, yes, I will.
You need to
I
get
will.
up. No, you need to get
I would
up
like
right
you
now.
to watch the documentary, Take Care of Maya. Take care of Maya.
Get up.
Take care of Maya.
Please.
You're gonna get up and you're gonna be.
I will.
Now.
I will leave.
Now,
I will leave on my own recognition.
This might be one of the most underrated but important moments in the entire hearing. The defense attorney, who is working pro bono, meaning he's not getting paid a single cent, is now considering withdrawing from the case. Let that sink in. This is someone who chose to help, who invested time and effort, and is now saying, "I can't do my job." That doesn't happen lightly. Attorneys are trained to handle difficult clients. But there's a limit, and we're watching that limit get crossed in real time. And the judge sees it too. She points out the reality of the situation. If he withdraws, the defendant could be left in a very difficult position.
now,
I will leave. I will leave.
now, you need to stand up, please. I'm asking nicely.
Now.
One more time.
It's gonna be much easier if you walk away.
Can I?
No.
I can leave. I can leave. Can you please let?
This way.
All right. So, Mr. Farrenholtz, you're gonna file a motion to withdraw.
I believe so. I mean, I'm doing this pro bono and certainly
I see everything of what's occurring. And I think if you file a motion to withdraw, can you put a note in the minute order that
Some more things in
she
here.
can apply for the public defender? I don't think she would fill out that application, but maybe there's
we get a different
incompetency
date than
for.
the 5th, just in case I don't file it.
Okay. She needs to be in competency proceedings anyway. You can think about it. If she is appropriately evaluated and they've determined maybe she needs some meds, she might be restorable. I don't know. But this is all competency issues. So, until she's stabilized, and I don't know what that's gonna look like. At least I was very close to having her incarcerated, but if she was incarcerated, she'd have to stay in jail for that evaluation.
We continue to hear it once I think she's not competent.
I know. I think this is probably overdue. A competency evaluation.
I don't know if it's
Is there-
over.
Is there a chance just to get a date on that competency? Because I don't want to be obligated either. This is my first vacation.
Okay, can you just put, now that she's gone, can you put in the minute order that we'll, on December 5th, we will need to continue it because Mr. Farrenholtz can't appear? And we'll give her a new date on that date and time.
Okay, so she'll go to court and I won't be there.
Yeah, and I have a note that you can't be there on that
Okay.
date and we'll reset it.
Okay, great.
What's the next date after? We can set it for December 19th at 1.
That's for both of those, right? The motions hearing and What's that? That's for both cases. Yeah, for both cases.
December 19th at 9.
At 1.
Yeah, I'm looking at their WebEx.
Everybody appears by WebEx in any
Okay.
event, so you can appear by WebEx each
Okay.
time. At this point, we would probably, if she's deemed competent to proceed, unfortunately, we'd probably have to have the motions hearing yet again. If she's deemed, thank you. Sorry for that.
Okay. She said she was waiting outside.
Uh,
Not quite, huh?
So,
Take care. Have a good Thanksgiving.
you too.
Yeah, have a good Thanksgiving.
Now this is where things take a serious turn. We've moved beyond simple courtroom disruption and into questions of competency. When a judge orders a competency evaluation, it's not about punishment. It's about determining whether the defendant is mentally capable of understanding the proceedings and assisting in their own defense. But at the same time, the judge is also warning about contempt of court. And that's a big deal. Contempt isn't theoretical. It can result in immediate jail time. The judge is essentially saying, this is your last chance. And what makes this moment so intense is the contrast.